Three political parties launched their elections manifestos ahead of the general election on May 29. We speak to Research and Advocacy Officer at Judges Matters Mbegazeli Benjamin on the removal of Western Cape Judge President John Hlophe and retired Judge Nkola Mutata from judicial office. And the Gauteng High Court in Pretoria has dismissed with costs the newly formed Labour Party's bid to seek an interdict in order to challenge the election timetable ahead of the 2024 general elections. A very good afternoon. If you've just joined us, we're coming to you live from our studios here in Auckland Park, Johannesburg. Welcome to Week in Review. Now, this is the program where we review some of the biggest stories to come out of the week. I'm your host, Mfundo Mabalan. Leading our bulletin this hour, three political parties are launching their election manifestos today ahead of the general election on the 29th of May. Today, Al Jamar Party launched its election manifesto in Lenasia, south of Johannesburg. Meanwhile, supporters of the African Christian Democratic Party are at Ellis Park in Johannesburg for the ACDP's manifesto launch. Also launching its election manifesto is the African People's Convention. Women will constitute the majority of the ANC's representatives to the national and provincial legislatures after May 29th elections. This was confirmed by party spokesperson Mahlengi Bengu ahead of the party's submission of its candidate list to the IEC.
Addressing the media at the party's headquarters, party spokesperson Mahlengi Bengu says the shortlisting process was fair and open. Mutsiri further said the party went through strict measures to ensure that they adhered to the renewal process, but also consider the point that being fingered in wrongdoing does not necessarily mean one is guilty.
There are of those that have been flagged by virtue of having been fingered in the State Capture Commission report and then subjected to the internal process of the ANC, going through that process up until a stage where there was an agreement that they are not eligible to stand as public representatives, and certainly for provincial legislatures.
Mutsiri also revealed its list will show how committed the party is in its stance of ensuring that those who represent the party are clean. The vetting process has flagged 4 senior ANC members.
Whatever allegation that is made against you always have got to be tested, and the rule of law needs to apply. So in that same way, every South African does deserve that. Of course, public representatives, of course, leaders of the ANC have a much more bigger moral obligation.
The ANC prides itself of having all sectors of society and its demographics represented in its list.
The representation of women, youth, living with disabilities, members of the LGBTQIA plus community, individuals, these have been paramount in the process of candidate selection, is also an indicative of the ANC's commitment to a list that reflects what South Africa truly is. The Electoral Committee received 2,457 candidates nominated for National Parliament. 31 comrades declined nomination. Amongst those are comrades who have served the movement admirably for decades and to whom we owe a sincere debt of gratitude for their contribution.
Meanwhile, as anticipation grows on the ANC's candidate list, some who have been serving for a while have weighed in.
I'm not going to Parliament, and I'm not going to Parliament because as you dance, you must also give other people a chance.
I'll let the ANC answer it.
It's in the hands of the ANC.
On Monday, the ANC head of Electoral Committee will release their list to the public. SABC News, Johannesburg.
Al-Jamar is one of the political parties trying to woo voters this weekend as it launches its elections manifesto in Lenasia, south of Johannesburg. Established 17 years ago with the aim of challenging the political landscape of the country, it has secured one seat in parliament and has won several wards in the Western Cape and Gauteng. This was in the local government elections. The party says it will support a coalition government if no party wins an outright majority in this year's general elections. Our reporter Nhlanhla Kgatlana is at the launch and joins us now with the very latest. Good afternoon, Nhlanhla. So Al-Jamar's core manifesto message is full employment with decent jobs for all. How is the party planning to make this possible?
Yes, well, a very good day indeed, Nomfundo. You had the party president of the party there, raising concerns about the state of the country, saying that their party is not obsessed with creating a lot of jobs, but their focus will be to create decent jobs, as you already said there. And also another issue that came out from their manifesto message, pretty much dwelling into the 30 years of democracy, saying that in the past 30 years, the judiciary still remains the same. He says that he feels that there is lack of transformation when it comes to the judiciary, saying that, the country, it's not democratic, saying that people are not the ones that govern, but the judiciary seems to be taking the position of governing. Also saying that under the ANC government, it's always about access. They don't talk more about rights, saying that if the party comes into power, that's basically where they're going to focus. Creation of jobs, transformation, real transformation of the judiciary, and also beef up rights when it comes to, children. But with us, I'm with the members of Al-Jamar, who are just going to talk to us with regards to their take in terms of what the party president said there. He also, put a disclaimer saying that he's not here to make a lot of promises, but he will make a minimum promises or few promises that the party will be able to achieve. Thank you so much for your time. Your party leader has spoken about unemployment, spoken about transformation of the judiciary, and thirdly saying that more rights to children. But South Africans, we are going through a lot. I mean, there's load shedding. There was nothing said about load shedding. Just pretty much your take with regards to what was said here.
Okay, thank you. My name is Tabo, the president of ILAU, which is an alliance to Al-Jamar. We are here today to support and also to tell the people of South Africa to vote for Al-Jamar. We're here to support the manifesto because what Al-Jamar has done in Gauteng province regarding workers, because it is Al-Jamar and our union that has been advocating for permanent absorption of all health workers in South Africa, particularly those who are labeled as EPWP and also those JMPD who are finding difficulties. It is Al-Jamar who's been the voice of those marginalized workers. So today when the president spoke about decent job, it is what us as ILAU, which is the alliance partner, we stand for. And they're not just saying that. We have seen the 130 employees of the city that were dismissed by Democratic Alliance government who are being reinstated, and the judgment came in their favor. And also there are 464 City of Johannesburg employee under Jose Hlomile, whom the DA terminated their contract 2 years ago. So the Al-Jamar is working tirelessly to make sure black child is well taken care of.
I hear what you're saying. Let's go to the message. Your take with regards to, talking about employment, talking about transformation of the judiciary, and also the reality of load shedding. Nothing said on that.
Well, let me start with the transformation of judiciary. We can see that most of the arms of our judiciary are captured, and we see that those that have financial muscle are not being persecuted because they can be able to pay the judges. So it is what Al-Jamar wants to change, and it is what Al-Jamar wants to bring change to, so that we become a law-abiding citizen and we become a law and order country.
Load shedding?
With load shedding, we just had a meeting yesterday, but with load shedding, I think it needs a national government. But as Al-Jamar, we are saying We need people of caliber of Machela Koko to be reinstated and to be able to resolve this issue of load shedding, because this is done deliberately by the government of the ANC.
Thank you so much. I'm going to bring another gentleman here. Your take with regards to what the president of the party said.
No, thanks. I think what is very important is that the president has outlined the manifesto, and the manifesto, in being a promise for the future, is actually a continuation of what Al-Jama has been doing in the last 17 years that it's been active in the different spheres of government. I think in the last 5 years we've seen Al-Jama grow in leaps and bounds, and ensuring people on the ground benefit from the different programs. I chair the National Villages League.
Wouldn't you have loved to hear him talk about, pragmatic challenges that South Africans face, except from, we know that unemployment is an issue, but there's also an issue of load shedding?
I think the issue of load shedding is a national issue, and it is, if you read our manifesto in completeness, it is discussed to an extent where we are saying that if we create an environment where we stop corruption, we stop other things, these entities and the state entities will be able to flourish again, and that's where we are with that.
Your take?
My take is that, the president has said everything so well, but I support the manifesto and everything. So, on the issue of the load shedding, as the previous speakers, they have said that it is a national issue. So as Al-Jama, we will deal with it as a matter of agency, because we have seen that, it is troubling our people a lot.
Are you hopeful, are you confident that this message that was sent, they will be able to make South Africans choose Al-Jama come election time?
120%. I'm hopeful, because Al-Jama, we have seen the impact that they have done previously in Johannesburg, in Cape Town. So there is no failure in Al-Jama. 100% we are going forward.
Well, Namfundo, there you go. There is no failure in Al-Jama. Saying pretty much this, that they really support what the president said. Here he spoke, like I said earlier, about the creation of jobs, and saying that they are not going to focus on jobs that have been created before in the past 30 years, but looking into today and the future. With that being said, it's back to you in studio.
Thank you very much, Nhlanhla. That's our reporter, Nhlanhla Khahlane, out in the south of Johannesburg for us. We shift our focus to this story now. The Gauteng High Court in Pretoria has dismissed with costs the newly formed Labour Party's bid to seek an interdict in order to challenge the election timetable ahead of the 2024 general elections. The party hauled the Independent Electoral Commission to court on the day of the latter's deadline for submissions in order to contest the general elections. Now, they were arguing that it seeks the interdict in the interests of free and fair elections. SABC News senior reporter Kenny Mapanga filed this report.
The newly formed Labour Party's 11th hour bid to seek more time to meet what it terms as the onerous requirements to contest the 2024 general elections did not yield the desired outcome, as the court dismissed the urgent application with costs.
As far as the court is concerned, the extent of the powers and functions of the electoral court is not limited in the manner as was submitted on behalf of the Labour Party. With this in mind, the court makes the following order. 1, the application is dismissed. 2, the applicant is ordered to pay costs.
The party approached the High Court instead of the Electoral Court on a subject which is at the heart of the country's electoral process, arguing that the Specialist Court did not have exclusive jurisdiction. The applicant argued the matter did not exclusively belong to the Electoral Court, as there was no adjudication of a dispute, which produces a decision.
An original administrative decision to establish a timetable was made in February, but that's something completely different to adjudicating a dispute. And the adjudication of a dispute, which produces a decision, is ultimately what triggers the exclusive jurisdiction of the Electoral Court. Before that, it doesn't have exclusive jurisdiction.
The IEC, however, was of the view that the election timetable was published in February, and the Labour Party was free to immediately approach the Electoral Court then, but chose to do nothing.
But what did the Labour Party do? It did absolutely nothing. Nothing. It didn't write to the Commission. It didn't lodge a dispute with the Commission. It didn't ask the Commission what it had done with the letter supposedly sent by other parties. It did nothing until Wednesday when it launched this application.
The 2024 general elections will be held on 29 May. While the Labour Party is registered, it is unclear whether it will meet the requirements to contest. Kani Mapanga, SABC News, Johannesburg.
All right, we're now joined by the Institute of Election Management Services in Africa's Terry Tsilani. Mr. Tsilani, good afternoon and thank you very much for your time.
Good afternoon to you and thank you very much for having me.
No, it's a pleasure to have you with us. So the court has dismissed the Labour Party's attempt to interdict the IEC's nomination deadline, as we heard there in that particular clip. There are already mixed views on the cost order in particular. Your views on just that ruling?
Well, as would have been expected, the fact that the matter was taken to the High Court would not really change anything in relation to the implementation of the election timetable and then all the milestones that are there in the election timetable. So the fact that it has actually been dismissed, I think it provides a little bit of certainty to the Electoral Commission in order to be able to proceed with its preparations for these elections and to make sure that all those that intend participating in the elections comply with the requirements thereof.
In certain quarters, there seems to be a concern that it perhaps sets the tone for future candidates seeking to assert their interpretation of what they view to be free and fair elections, particularly saying that they're discouraged by the decision to grant cost orders.
Well, the court may be wary of the fact that each and every political party or an individual who does not agree with certain decision of the Commission will approach the court in order to try to prevent the smooth running of the elections. And this is basically, in my opinion, one of those attempts, or rather one of those decisions that are aimed at making sure that, we should not actually have frivolous challenges to the electoral processes.
All right. And then I want to take you to Thursday. There was another significant development that opened a conversation around the timelines or new rules that smaller parties have to comply with. Besta. They, of course, have complied, going beyond the required 60,000 signatures. They got 140,000. But Mmusi Maimane felt it important to state that there were serious hurdles before them that the IEC had placed. What did you make of that address? That here we are, we have complied, but we feel we're going to come to the IEC's offices and address exactly and tell the nation what we had to contend with.
I think the criticism against the Commission is misplaced in a sense that the Commission does not make the law. It is Parliament that made the law. It is Parliament that passed the Electoral Amendment Act and then made those requirements for new political entrants. And therefore, the Commission, all it has to do is to implement what Parliament has decided on. And therefore, I don't think the hurdles that they're talking about have actually been put by the IEC, but rather by Parliament. And therefore, that's the institution that can actually be criticized if at all any person is not happy with the current Electoral Amendment Act. But of course, there are quite a number of people who had raised issues even before these elections. And the fact that the minister has taken a decision that is going to be appointing a panel that will be looking at the overhaul of the electoral system, is testimony to the fact that this Electoral Amendment Act has got some weaknesses, and therefore those weaknesses, unfortunately, could not be addressed before the current elections.
Most certainly, because the timelines were truncated there as well. But you make a very important point that it was the legislatures, those who sit in Parliament, the lawmakers, that are perhaps the ones that should be challenged on what came out of this Electoral Amendment Act and not necessarily the IEC. So in that aspect, it seems that mostly the message is lost. A lot of people are targeting the IEC. But beyond this, Mmusi Maimane also stated that at least on the voter education element, it was within the competency of the IEC to say here, you could have gone to the people in society and told them that we have smaller parties and independents now. And these are people that could possibly knock at your doors and ask for ID numbers and telephone numbers. In a country where fraud is quite prevalent, please do note that there are smaller parties that would be knocking and asking for important information. He says they failed in that respect. Never mind the Electoral Amendment Act, but just this aspect of having to require personal information from people, that it's difficult.
Of course, the Commission is partly to be blamed for lack of voter education. But remember that voter education is not only the preserve of the Commission. It's a joint responsibility between the political parties, civil society organization, and the Commission. And the fact that the Commission has got limited resources, I would think that they would prioritize funding the logistics and the management of the electoral processes and sacrifice vote education when they do not actually have sufficient resources to be able to run a very smooth election.
Now, this next question is not necessarily within the purview of the IEC, but generally speaking, to allow for free and fair elections and for greater participation of these smaller parties. He touched on money, that aspect, that we cannot be naive and think that a party can function on social media. You need to mobilize people on the ground, and to have people on the ground costs money. What are your views around just this aspect of the honest need for money if you are to find yourself on the ballot?
It's quite a critical point in the sense that represented political parties do get funding from the fiscals through Party Funding Act. Now, the problem and the challenge is those who are not represented in Parliament, because it becomes quite a difficult thing in terms of the coordination of all those that are outside and making sure that they are also able to play a role in terms of strengthening constitutional democracy. But as matters stand, currently the legislation is such that funding for political parties from the fiscals is only through Party Funding Act, and the parties that are funded are only those that are represented in Parliament. And then that's where the discrepancy appears to be. And therefore, if those that are not represented in Parliament can come up with creative ways of trying to show how they believe that this particular issue is attended to without opening a door for frivolous participants to come in and benefit from the money from the fiscals, I think it would be very useful.
Because he ended up saying that it inadvertently leads to some sort of a protection of the status quo if you cannot allow new entrants with new, fresh ideas to come in, because it's an arduous task that is before them.
I think it is a legitimate concern, like I said. But at the same time, we've got to understand the complexity of having to try to fund parties that are not represented in Parliament. It might be very difficult because currently you've got more than 350 political parties that are registered. Now, what mechanism are you going to be putting in place to try to assist those 350? And then how many of them are really serious players and they really want to participate in the electoral processes? So it's a balancing act that the country has got to make, because also the money from the fiscals is not unlimited. There is a certain amount that can be made available to the political parties as part of this, because we've got many competing interests within the society: education, housing, unemployment, and all those other challenges that are there within the society. So taxpayers cannot always be spending every cent of the money in the fiscals to fund political parties. We've got to try to channel money in such a manner that we are still able to meet the needs of our society and making sure that, the basic services are provided to our people.
And then broadly speaking, yesterday was another milestone for the IEC in their timetable. The 8th was now the deadline for the nominations list to be submitted. Your take on just how the IEC has been acquitting itself thus far?
I think so far they've done a good job. They've obviously just started, in a sense that, the submission of the list of the political parties and independent candidates is one. It's the first major step in the achievements of all the milestones within the election timetable. So there's still a lot of work that they still have to do, but so far so good. We will see now what happens in terms of compliance by political parties and which ones are actually compliant to be eventually on the ballot paper.
There's also a lot of conversation around the leaked lists. We haven't as yet been able to authenticate that indeed those are the lists, but there are a lot of lists that are now circulating on social media, which is quite concerning. And some have said that possibly it would have been leaked on the side of the IEC, while others say it's probably in your offices. What do you make of just that? Because you've got some that are saying it will give an advantage to some other political parties if other lists are exposed prematurely.
I think the Commission has got to strengthen its security around all aspects of the electoral process so that something like this does not recur. And fortunately, they were the first to admit that this actually happened in their offices and they're attending to it. And I just hope that going forward, we're not going to be seeing anything similar to this because it can cast some aspersion on the management of the electoral processes. And I think the Commission is well aware that this is a highly contested elections and then they don't want anything that is not supposed to be in the public to find its way in social media or in the public eye. They've got to try to put in place all mechanisms to make sure that they protect the integrity of the process.
Does the premature leaking advantage any other political party in any way?
Well, at this stage, we can't tell if it is going to be advantaging anybody because at the end of the day, all the lists are going to be made public very soon, and therefore those that want to object can object at that stage. They're going to be given a period within which to object to a party or the list or individuals that are contained within the list of a political party during that particular period. So the fact that it has been made public prematurely, I don't think really is going to create any advantage for any political party at this stage.
So you're saying for those that argue that perhaps now it allows for opposition to conceptualize cogent arguments against any particular candidate if they wanted to object, that now they would have ample time to investigate and put together a cogent argument to object about a certain candidate. It really is far-fetched, according to you.
I think it is far-fetched in a sense that, as I've indicated, that the lists are in any case going to be made public. And I think to a large extent, especially when it comes to major political parties, one can always guess, the kind of the individuals that they're likely to put in those lists. And therefore, if, a party or an individual is going to be objecting, they've had ample time to research and find more information about the people around which they want to object. And this few days would not really advantage any political party or an individual to the extent that others are not advantaged.
All right, Mr. Tselane, it's always a pleasure to have you with us in studio. Thank you very much for your time. That was Institute of Election Management Services in Africa, Mr. Tselane. To other news now, the National Assembly Speaker has explained her reasons for hiking the salary of Xolile George months after his appointment as Secretary to Parliament. The Powers and Privileges Committee confirmed that Nosiviwe Mapisa-Nqakula responded to a complaint by the Democratic Alliance. Acting chairperson of the committee, Dr. Manketsi Tlhape, gave no further details except that they received a written response from the Speaker. The DA has now called for a swift resolution to the matter.
Mapisa-Nqakula had until the end of this week to make written representations. The Powers and Privileges Committee will use the response to determine whether to institute an inquiry into her conduct. The DA's complaint alleges that the Speaker violated the Code of Conduct and Ethics for members by improperly hiking George's salary and allegedly being economical with the truth about it. George was appointed on a 2.6 million rand annual salary in line with the job advertisement. However, news reports stated that his salary has been increased to 4.4 million rand. George was appointed in June 2022 and the salary adjustment reportedly happened months later. If Mapisa Ngakula's written representations to the committee is not satisfactory, she may be called to give oral evidence. Parliament spokesperson Muloto Tabo referred all media enquiries to the committee. The DA welcomed the Speaker's response and called for swift action.
This response comes at the back of the DA's complaint to the committee that the Speaker gave the Secretary to Parliament, Mr. Olile George, an over 70% salary hike while hiding this fact from Parliament where this appointment was agreed to. So we await for the Powers and Privileges Committee to give us the way forward. We are aware that the committee is convening on Monday. We call upon the members of that committee and the chairperson to move with speed, to act without fear or favor, because we cannot have a scenario where the head of the legislative arm of state, the Speaker of the National Assembly, is suspected of having misled Parliament by hiking a salary that was not approved by the House. And we look forward to the outcome of this investigation.
Tulilani Philip, SABC News, Parliament.
Welcome back. Thank you very much for staying with us. Now, co-accused in the Tabo Besta escape case, Dr. Nandipha Makutumana has threatened to launch an urgent application in the High Court. This is to stop the release of Showmax docu-series tracking Tabo Besta, which is set to premiere on Friday. Her lawyers wrote to the MultiChoice Group and Showmax on Friday, asking for a full copy of the 4-part docu-series by today. This is to establish if there are any issues contained in the episode which could prejudice Makutumana's rights. In her letter, her lawyers say she did not grant any right, permission or authority to any party to film, and no personal interviews were held with her, which they say raises concerns regarding the accuracy and correctness of the versions which are to be shown. It further states that if any facts are disclosed inaccurately or incorrectly, the documentary series would not only be premature, but it will constitute a reasonable apprehension that their client's rights to defend herself would be severely prejudiced. President Cyril Ramaphosa has officially informed suspended Western Cape Judge President John Hlophe of his removal from office. This follows the National Assembly's recent impeachment vote, which saw 305 members of parliament voting in favour of his removal and 27 against. This makes Hlophe the first judge to be impeached since the dawn of democracy, and he loses all his benefits and pension. Meanwhile, the impeachment of retired Judge Nkola Mothatha has been finalized. This makes Mothatha the second judge to be impeached since the dawn of South Africa's democracy. For more, we're now joined by Mbekezeli Benjamin, who's a research and advocacy officer at Judges Matters. Mbekezeli, good afternoon, and thank you very much for joining us.
Good afternoon, Fundo, and thank you very much for having us.
It's a pleasure to have you with us. So the President has affirmed the removal of the two judges. The parliamentary impeachment outcome has, of course, been reflected upon. But Judge Hlophe seems to be forging ahead with his legal challenge of that whole process that was followed that led to the ultimate impeachment. Your views on just where we are now?
Well, where we are now, as of this week, is the President has carried out the resolution that was taken by Parliament to impeach both judges and remove them from office. You'll recall that Section 177 of the Constitution is very clear on the process for removal of the judge. It starts with the Judicial Service Commission undertaking a tribunal to investigate claims that was filed against the judges of misconduct. From the Judicial Service Commission, they make a finding of gross misconduct, and then they refer it to Parliament. Parliament then has to debate that outcome and then vote on it. And this is something we saw in the last couple of weeks. And once Parliament has taken the vote, and by 2/3 they vote to remove the judge, then the President must, and this is what Section 177 subsection 2 says, the President must must carry out the resolution. And how he does that is to sign a proclamation with the exact date from which that particular person will no longer be referred to as a judge. And this is something we saw this week on the 5th. So the process now is that the two gentlemen have now been removed as judges officially. We do understand that Mr. Hlophe has now gone to the Constitutional Court to challenge the process that was undertaken by Parliament. And he says that the process was not allowed to come up with new rules for the impeachment of judges. Of course, Parliament denies this, and the High Court in Johannesburg also told us that Parliament doesn't need to come up with new rules. They simply need to consider the information supplied by the JSC and debate it and take a vote, which is what happened.
And Parliament had also stated that it was not for them to duplicate the process that the JSC embarked upon. But his legal representative, former Judge Mr. Hlophe, his legal representative maintains that Parliament should have put together rules for an impeachment. And when you look at that section 177 of the Constitution, as you rightfully state, it does basically indicate that it starts with the JSC and then it goes to Parliament, which must then adopt the resolution. They seem to be suggesting that Parliament was not precluded from putting together the rules there, that it's not stipulated, but they could have decided to allow for rules that allow the former judge to make representations to them and for them to arrive at their own decision independently. What is just your take on that argument?
Well, I respectfully disagree with legal representatives. And perhaps it might be useful to look at the other sections that deal with impeachment. For example, for the impeachment of the president, the Constitutional Court said Parliament does have to come up with rules to govern the impeachment of the president. The same, the Constitutional Court said the same for the public protector, that they had to come up with rules for the impeachment of the public protector. And the reason for that is because for both the public protector and the president, the process starts and ends in Parliament. So the rules are there to make sure that the process is fair, to make sure that the Parliament is able to hear witnesses, is able to cross-examine the witnesses, is able to undertake the inquiry that is required in terms of the Constitution in order to reach the impeachment decision. But for judges, it is completely different. For judges, the inquiry process happens at the JSC, which is why there needed to be a tribunal. The tribunal heard the evidence, cross-examined the witnesses, and made a finding. Once that finding was made at the tribunal stage and it was confirmed by the JSC, all that is needed is for Parliament to vote on it, because Parliament rightly says it would be a duplication if they had to undertake the witnesses and the inquiry again. And that is why even now, I believe that the legal representatives of Mr. Hlophe are wrong to say that the Parliament should have come up with rules, because there is no need to do so.
You raise a very important point there where you seek to distinguish between the two processes, because it seems as though even in social media there were attempts to draw some similarities between the impeachment of the public protector and now the impeachment of the two judges. That you're saying we must remember that with the impeachment of Busio Mkhwebane, there was no inquiry that was held before. What happened was you had a political party that went through scathing judgments, put together those judgments and said, beyond these judgments, we believe there should be some sort of inquiry that looks into her overall fitness to hold office. Those judges had not set to inquire. It was more of an oberdictum, where these were statements made in passing in some of those judgments where it became very scathing statements. They compiled these and then said Parliament must start an inquiry. Unlike the judge here where inquiry sat, there was the tribunal. What do you think then is playing out here if something as simple as this, that they're not the same, seems to be a particular element that they're going to the Constitutional Court with? What is at play then?
Well, look, I'm also surprised at what is ultimately being sought to be achieved, because I've read the papers for the Constitutional Court, and many of the issues that are raised in those court papers were raised in the Johannesburg High Court. you'll remember after the tribunal made a decision and the JSC was now considering whether to uphold the guilty finding of gross misconduct and whether to recommend impeachment, then Judge Hlophe took it to the Johannesburg High Court. The Johannesburg High Court, a full bench of 3 judges, considered all of these issues and dismissed all of them. And that's where they came up with the route that should be taken in terms of the role of the JSC versus the role of Parliament. That was a decision of the High Court in 2021, and that decision, Judge Hlophe took it on appeal to the Supreme Court of Appeal, but he never went ahead with that appeal, and now he skips and goes to the Constitutional Court. So there does seem to be sort of gaming of the system, in my view, and that's why I strongly believe that the Constitutional Court is unlikely to hear this, and even if it does, it's highly unlikely to reverse or set aside the process that has been taken by Parliament and the President.
When listening to Judge Hlophe's legal representative, he keeps on talking about the lack of a record, that there was no record that parliamentarians actually looked at. He went as far as saying there was not even a 2-pager. So when they were voting against what, beyond just hearing that he has been found guilty of gross misconduct? What did you make of just that position of saying there was no record? What were they considering?
Well, we would have to look at the history of what happened. After the JSC had made a finding of gross misconduct,
oh, so unfortunate. What a lovely conversation with Mbegezeli Benjamin there. Quite a lot of insight. More news on the other side of this break. Do stay with us. Welcome back. Thank you very much for staying with us. Now, Auditor General Tsakani Maluleke says the powers given to her office to deal with cases of material irregularities are bearing fruit. She says they managed to recoup some of the monies lost through material irregularities by invoking these powers. This is after identifying 266 accumulated cases of material irregularities with an estimated financial loss of more than 14 billion rand.
Maluleke briefed the Standing Committee on the Auditor General on material irregularities of national and provincial departments. These cases have been accumulated since 2019-20 financial years through to 2022-23. The AG is empowered to recommend how the material irregularity should be addressed and also give timeframes. She says there are positive outcomes.
We've now calculated that 1.29 billion rand of financial losses have been recovered, with 500 million rand being in the process of being prevented as financial losses, and 700 million rand being in the process of being recovered.
She has issued a material irregularity on the Department of Defence and Military Veterans due to the department's failure to use medical equipment.
If by the date given there, which is the end of March 2024, the department has not acted on this MI, we will then move on to either a referral or to taking binding remedial action, which is reviewable only in a court of law.
Maluleke says some matters have been referred to investigating bodies, adding that most cases of material irregularities are about non-compliance in procurement processes resulting in overpricing or appointed supplier not delivering. Lula Mamacha, SABC News, Parliament.
Women leaders have gathered at the Johannesburg Stock Exchange to celebrate International Women's Day. Brought together through the Motsepe Foundation Gender Equality, Wellness and Leadership Summit, it was an opportunity to look at how far women have come economically and to look at the remaining challenges and how society at large can address the issues.
Women ringing many bells at the opening of the Johannesburg Stock Exchange this morning. This, as the Motepa Foundation brought men and women together at the JSE to talk about the triumphs and challenges faced by women on International Women's Day. The JSE says it, as a company, has made good strides in the area of gender advancement, with 56% of its board members being female and 70% of its executive managers being female. But it says it's acutely aware of the challenges that women more broadly face in the South African economy and spearhead a number of initiatives specifically to improve the lot of women.
We have our flagship event, She Invests, that promotes financial literacy and empowers women so that they can make sound financial decisions and also grow their prosperity.
The consensus here is that the inclusion and empowerment of women were essential for fostering a thriving and prosperous society. However, even business representatives observe that more could be done to better achieve the employment equity targets set by government.
We know that year in, year out, the Department of Labour issues the Commission of Employment Equity report, which shows the numbers, which shows how we as businesses are dismal in terms of meeting those targets. And there is no consequence, there is no penalties. You know, we are not being dragged, kicking and screaming as business to make sure that we do the right thing.
Women leaders gathered here emphasised the importance of women needing to participate at the ownership level, that is, owning the means of production, with big industry being urged to be more deliberate in its inclusion of women in their enterprise supply development schemes, with an emphasis on ultimately contracting female-led businesses on a long-term basis.
The only chance we have of owning South Africa's productive system is to ensure that more women own businesses in those sectors, whether it's energy, whether it's automotives, whether it is manufacturing or textiles. But we have to take a much more intentional, technical approach to understand what is the value chain for each of the 17 sectors. Where are the opportunities that women-owned businesses can enter that space, number one. Number two, be supported to actually begin to operate in that space. So then ecosystems of support, such as financing, enterprise development, become critical.
When it comes to gender equity at South African banks, some progress has been made, with notable improvements at chief executive levels, or what's termed as C-suite level.
I think in the C-suite environment of the banks, we're starting to see a lot of progress. You know, you have, yes, there's VC sitting right next to us, but in the banks you have Funeka Manjani, Mary Vilagazi, Hema Sadiki. You know, there are quite a few women that have now risen to C-suite environments, and below them there's a good pipeline. The rest of the ecosystem has a way to go. You know, the brokerage firms, yes, there's a Erica Bruce, there's a VUAD, but really when it comes to the people with the capital, the private equity firms, the asset managers, I think there's development to be highlighted there.
Apart from having enabling legislation and corporates doing the right thing by implementing gender equity policies, there was also an emphasis on women business and non-business organizations at different stages of development, collaborating more with each other to exchange ideas and share best practices, thereby promoting incremental growth and development in the process. Nompumelelo Siziba, SABC News, Johannesburg.
President Cyril Ramaphosa says Israel is ignoring the World Court's provisional orders aimed at stopping the Israeli bombardment of Gaza. South Africa has again submitted a request to the court to examine whether additional provisional measures are required to protect Palestinians caught up in the Israeli-Hamas war.
The Israel Defense Force is continuing to attack Gaza. More than 30,000 Palestinians have been killed. The United Nations Security Council has failed to adopt a resolution on ceasefire. The ceasefire talks have collapsed. There is not enough progress in delivering aid to Gaza. Pretoria says the situation is dire.
I wish I could say to the people of Palestine and all Muslims, Ramadan Mubarak. But for the people of Palestine, I'm just seeing a very deadly situation if the world does not address this urgent matter of an immediate ceasefire.
The alarming situation has led to South Africa filing another submission to the International Court of Justice.
We approaching the court once again because
Israel has not been complying with the order that was issued by the court. So we've seen it fit to approach the court on an urgent basis, particularly with the view of addressing the challenges in the Rafah area, where a few days ago more than 100 people were massacred. And we want the court to take another decision on that, on how it addresses that and forestalls the occurrence of any other occurrence. Now, the one other concerning thing is that starvation, which many organizations have been warning about, has now arrived. People in Gaza are now starving. There is no food, there is no usual facilities like water, and people are dying, and especially young children are dying as a result of having no food. People have no food in their homes, and that is why as delivery vans or trucks come, there's a scurrying for food, and which is a natural reaction. So our action is aimed at also addressing that, because the people of Palestine are really suffering. In Gaza, the suffering is beyond human contemplation or understanding.
The veterans of the ANC support Pretoria.
Even now, I mean, it's very strange how quickly situations change. I mean, early last year, around April or so, there were massive demonstrations against Netanyahu in Israel itself. Today, he's presenting himself as the Prime Minister leading a war cabinet. And clearly, to him, the war must never end. Because if the war ends, he will have to account.
The only way to solve this problem is to address the problems that have been created since the creation of the State of Israel. But hopefully the rest of the world, the whole world, can unite behind that perspective to say fundamentally, really tomorrow if it can be done. Let's address these challenges facing the Palestinian people, resolve that matter, and that's what will end the violence in the Middle East.
And a strong message to the Prime Minister of Israel.
One would say, not from me, but the world is saying that, stop. This is now your legacy. You will end up being known as nothing but a mass murderer, a killer, and so on. You have reversed now the Holocaust, and you put Palestinians in a situation where Jews once were. That's why we support the Jewish people who are standing up inside Israel. We're saying this must stop.
Meanwhile, an Israeli activist is in the country lobbying support for those who were sexually abused during the hostage drama.
The first thing that the international community need to do is to believe the victims, to believe the survivors, to believe people that said that it's happened, because right now, in the first time in history, people don't believe, and people are saying that it's not happened in armed conflict, and there is no reason for that. People need to believe the victim.
Your message to the international community?
Believe the victims, believe the Israeli victims, believe the Israeli survivors when they're saying that we were raped, we was assaulted. Believe them and raise your voice against it.
On the eve of International Women's Day, many women are being harassed and sexually abused, while others have not lived to see this year's International Women's Day. An indictment on the world leaders. Sophie Mukwena, SABC News, Johannesburg.
All right, and that's where we leave it for today. We're back tomorrow. Enjoy your afternoon further.